Universitas Mulawarman Jaya. Jaya.
Faculty of Law, University of Mulawarman, one of the best in Kalimantan. It is not only held 3 services on higher education. More than that, we have integrated to Kalimantan environment. Kalimantan, 3rd biggest island in the world, having tropical forests across the land. Kingdom of 100 animals, place of 100 plants grow, home of people with unique culture, miles of river winding, wonderful coast, rich in natural resources, a conservation, the earth lungs and paradise, the most breathtaking gift from God for humankind. Today, Kalimantan reveals its darkest side of human greed. Coal mining exploits land without mercy. Mining pits welcoming innocent life. Sand beach is no longer whispering. Even the mangroves disappeared. Waves crashing away. The forest began collapse, destroyed by voracious machine. Kalimantan rage. Therefore, to prevent such disaster, Faculty of Law encourage sustainability, the future of Kalimantan, within specific curriculum as follows: Law of Coastal and Sea, Law of Forestry, Climate Change Law, Mining Law. Faculty of Law will continue preserving environmental sustainability for future generations of Indonesia.
Assalamualaikum warahmatullahi wabarakatuh. Good morning and welcome to all participants of International Conference and National Meeting, Law Laboratory Association of Indonesia, with the subject, Strengthening the Role of Legal Laboratories in Development of Nation Economic Law based on independent learning on independent Kamasos. First, I would like to greet our honorable mentions. The Rector of Mulawarman University, represented by the Dean of Faculty of Law. Leader of the Law Laboratory Association of Indonesia. Chair of Faculty of Law and the others. All today's speaker, Professor Dr. E. Gusti Ayu Ketut Rahmi Handayani, Bachelor of Laws, Masters of Laws. Professor Fokke J. Fernhout. Tara Prasad Sapkota, Master of Laws, Ph.D. Professor Rohana Abdul Rahman. Professor Dr. Juajir Sumardi, Bachelor of Laws, Masters of Laws. Dr. Mahendra Putra Kurnia, Bachelor of Laws, Masters of Laws. The panelists, and our warm greetings to all participants online and offline. This conference not only accessible through Zoom and at Mulawarman University, but also accessible on our YouTube under the name Faculty of Law, Mulawarman University. As a form of effort, the Faculty of Law, Mulawarman University, plays an active role in preserving traditional culture and also as a welcoming for all participants today of the International Conference and National Meeting, Law Laboratory Association of Indonesia. Let us watch the contemporary dance Dayak that will be performed live by the students of Faculty of Law, Mulawarman University. Before we start, I would like to tell the synopsis of this contemporary dance. This dance tells the story of girls that dance with joy to welcome invited guests. Using the property of a hornbill bird, that dances symbolize the calm dance from the Dayak girls. In Dayak Kenyah tribe, hornbill plays a very important role. Many people use it in traditional ceremonies and dance property. Based on the beliefs, the Dayak Kenyah tribe, their ancestor came from the sky and came down to earth in a form the resemblance as a hornbill. Therefore, this dance is also performed in various audiences. Ladies and gentlemen, all participants, may I present to you the Dayak contemporary dance. Next up, after seeing such a beautiful performance from the Dayak Contemporary Dance, may I ask all participants, please remain standing up for our national anthem, Indonesia Raya, and Mars of Mulawarman University.
Universitas Mulawarman, langkah ke masa depan. Ilmu di dada, agama di jiwa, berasas Pancasila. Universitas Mulawarman, harmoni kehidupan. Universitas Mulawarman, tonggak sejati nusa bangsa. Indonesia, Universitas Mulawarman, denyutna di masa datang. Ilmu di dada, agama di jiwa, berbakti untuk negara. Universitas Mulawarman Jaya. Jaya.
May all participants remain to be seated back. After singing our national anthem and the march of our beloved campus, we might now listen to the recite of tilawah, which will be read by the Faculty of Law student, Mr. Muhammad Nur Rahman. For Mr. Muhammad Nur Rahman, please lead and join us on the stage.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. naba'ul khasmi istazawwarul hisram Istakhalu ala Dawud fazi'a minhum qalu la takhaf khasmani bagha ba'duna khasmani bagha ba'duna ala ba'din fahkum bayi haqqi wastis'una jatahu walina'jatu wahidatu faqala aghfirliha wa'adzani fil khitab in hadza akhi lahu tis'u wa tis'una na'jatan wa lina'jatu wahidah walina'jatu wahidatu faqala aghfirliha wa'adzanil khitab Sadaqallahul azim. Assalamualaikum warahmatullahi wabarakatuh.
After hearing the recite of the tilawah, next up, we will be hearing the prayers that will be led by Mr. Muhammad Mashikur, Bachelor of Economics, Master of Science. For Mr. Muhammad Mashikur, please lead and join us on the stage.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera bagi kita semua. Hadirin yang kami hormati, marilah sejenak kita berdoa dengan khusyuk menurut agama dan keyakinan kita masing-masing. Dan izinkan saya untuk memandunya sesuai dengan tuntunan agama Islam. Amin amin ya rabbal alamin. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Hamdan na'imin, hamdan syakirin, hamdan yuafi ni'amahu wa yukafi'u mazidah. Ya Rabbana lakal hamdu wa lakal syukru kama yanbaghi li jalali wajhikal karim wa 'azimi sultanik. Allahumma salli wa sallim wa barik ala sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Ya Allah, Tuhan yang Maha Esa, hanya kepadamu kami panjatkan puji dan puja dengan segenap rasa. Engkau telah ciptakan luasnya langit dan indahnya bumi dengan segala isinya. Engkau pula lah yang mengatur semuanya dengan segala kuasa. Karena hanya kepadamu kami serahkan jiwa, raga dan karsa. Dan hanya kepadamu kami tujukan permohonan dalam untayan doa. Ya Allah, Tuhan yang Maha Pemurah, atas berkat rahmat karuniamu yang melimpah, kami hadir bersama dalam acara yang penuh berkah. yaitu acara International Conference and National Annual Meeting Law Laboratory Association of Indonesia. Ya Allah, Ya Rob, Ya Malik, hanya karena kuasa-Mu kami dapat berkumpul di sini, bersama di hari ini, berdiskusi untuk berbagi ilmu dan berbagi rasa syukur atas nikmat-Mu yang tak ternilai. Ya Allah, Ya Rahman, dengan memohon ridho-Mu, berkahilah semua langkah dan perbuatan kami. Kuatkanlah kami dalam setiap koordinasi. Bukakanlah pikiran kami dalam analisa setiap indikasi. Mencipta rumusan, kesimpulan yang efektif dan presisi, terukur pada hasil untuk membuahkan prestasi. Ya Allah, Ya Rahman, Ya Rahim, Engkau yang Maha Kasih. Anugerahkan ridho-Mu atas waktu yang Kau berikan. Kasih persaudaraan yang kami rasakan atas segala rezeki-Mu yang Engkau karuniakan. Jadikanlah kami sebagai hamba yang selalu bersyukur atas nikmat yang Engkau limpahkan. Rabbana taqabbal minna innaka antas samiul alim wa tub alaina innaka antat tawwabur rahim. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzaban nar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
After hearing such a prayer, that hoping today's conference and national meeting will be fully blessed. Next up, we will be hearing the committee report for the International Conference and National Meeting, Law Laboratory of Indonesia, that will be presented by the leader of the committee. For Dr. Nur Arifuddin, Bachelor of Laws, Master of Laws, please join us on the stage.
Assalamualaikum warahmatullahi wabarakatuh. Om Swastiastu, salam kebajikan, namo buddhaya. Peace be upon us all. Good morning all of speakers and participants offline and online, whom we respect are the honorable distinguished speakers, Prof. Fokke Fernhout, Faculty of Law, Maastricht University, who often visits the Faculty of Law in Mulawarman. Prof. Rohana, Abdul Rahman, lecturer at Universiti Utara, Malaysia. The honorable distinguished speakers, Prof. Dr. Tara, Prasad Sapkota, lecturer at Tribhuvan University, Kathmandu, Nepal. Chairman of the Integrated Law Firm and Consultancy, Kathmandu, Nepal. The fourth, the honorable distinguished speakers, Prof. Dr. Juajir Sumardi, SHMH Chairman of ALHI for the 2022 to 2026 period, and the Professor of International Economic Law at the Faculty of Law, Hasanuddin University. The fifth, the honorable distinguished speakers, Professor Dr. Gusti Ketut Rahmi Handayani, SHMH, Professor of Economic Law at the Faculty of Law, Universitas Sebelas Maret, ONS Solo. The honorable distinguished speakers, Dr. Mahendra Putra Kurnia, Dean of the Faculty of Law, Mulawarman University. Esteemed invite guests, speakers offline and online, seminars, participants from various law faculty in Indonesia universities, and all their respected committee members. We offer praise and gratitude to the presence of the Almighty God as we gather here today for the International Conference and Annual Meeting of the Law Laboratory Association of Indonesia, ALHI. I humbly welcome all of you to this extraordinary international seminar organized by the Associate Laboratorium Hukum Indonesia in collaboration with the Faculty of Law, Mulawarman University. This event serves as an important occasion for academics, researchers, and practitioners in the field of law to share current knowledge, ideas, and innovations related to legal studies. With the chosen theme, strengthening the role of legal laboratories in the development of national economic law, beside on independent learning, on independent campus. We hope that this seminar will be a constructive platform that encourage in-depth discussions and critical thinking about the role of law in understanding legal theories, concepts, practices, and the social evolution law of society. We believe that this meeting will foster close cooperation among the attending experts and generate new insight and creative solution to the challenge of current legal education and quality in Indonesia. This conference will include the ALHI National Work Meeting and will conclude with the signing of a MOU, Memorandum of Understanding between the member law faculty of ALHI and City Tour of Titik Nol IKN and observing its development. The event is attended by 82 international journals from universities in Indonesia. We express our sincere gratitude to all the authors and manager of the Mulawarman Law Review Journal. If there are any shortcomings in the organization of this event, we as the committee sincerely apologize for any inconvenience caused. In conclusion, may this seminar serve as a beneficial platform for all participants offline and online, and may the discussion generate result in valuable ideas discoveries for the development of law laboratories in Indonesia. Thank you for your attention. Participants, wassalamualaikum warahmatullahi wabarakatuh. Thank you.
After hearing such a welcoming report and a welcoming from the leader of the committee, next we will be hearing the speech from the leader of Law Laboratory Association of Indonesia for Mr. Professor Dr. Juajir Sumardi, Bachelor of Laws, Master of Laws. Please join us on the stage.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semuanya. Om Swastiastu, Namo Buddhaya, salam kebajikan, Salam. Good morning everyone. The Honorable Rector of Mulawarman University, the Honorable Dean of the Faculty of Law, University of Mulawarman, the Honorable all of the keynote speaker at the international conference, especially Professor Cara Prasad Sapkota, Professor Fokke Fernhout, Profesor Rohana Abdul Rahman, Profesor Gusti Ketut Rahmi, and Dr. Mahendra Putra Kurnia. The Honorable all of the Deputy Dean of the Faculty of Law, University of Mulawarman, the Honorable all of the member of the Indonesian Law Laboratory Association, the Honorable of the International Conference participants who attended in or via Zoom media. First of all, allow me to express my praise and gratitude to God for His blessing, so that the international conference activities held in collaboration with the Faculty of Law, Mulawarman University, and the Indonesian Law Laboratory Association can be carried out this morning. This international conference established the theme of strengthening the role of legal laboratories in the development of national economic law on independent learning or independent campus. The theme of this conference was determined on the trend in legal development on a national and international scale toward the trend of national and international economic development. For this reason, the Indonesian Legal Laboratory Association intend to play an active role in developing legal curricula in economic law. For holding this international conference, I, as General Person of the Indonesian Law Laboratory Association, do not forget to express my deepest thank you so much to the Dean of the Faculty of Law, Mulawarman University, for his willingness to collaborate in implementing of this international conference. I also don't forget to thank all the presenters who are willing to be keynote speaker at today's seminar. Likewise to all conference participants, both as regular participants and participants who participated in a call for paper, I don't forget to thank you. I would like also to express my thanks to the organizing committee who have worked hard to make this conference a success. I realize that the implementation of this conference, there must be shortcoming, both intentional or unintentional. For that reason, on behalf of the Indonesian Law Laboratory Association, allow me to apologize. Happy discussion. Wassalamualaikum warahmatullahi wabarakatuh.
After hearing the speech from the leader of Laboratory Association of Indonesia, next up, we will be hearing the opening speech from the rector of Mulawarman University, that will be outspoken by the Dean of Faculty of Law, Dr. Mahendra Putra Kurnia, Bachelor of Law, Master of Law. Please join us on the stage.
Assalamualaikum warahmatullahi wabarakatuh. Good morning to all of participants. Actually, this will be Mr. Rector here, but I have to deeply apologize from our rector because he is now in Kinabalu, Malaysia, because he has to attend the festival Borneo of Art and Culture. So she allowed me to give a welcoming speech from our rector. Actually, Mulawarman University, with the main specific pattern of tropical studies as the basis for the implementation of the Tridharma Perguruan Tinggi, always support every activity oriented to the development of science and community service. The International Conference and National Annual Meeting Law Laboratory Association of Indonesia with the theme Strengthening the Role of Legal Laboratories in the Development of National Economic Law based on independent learning on independent campus and continued with a tour to the Nusantara capital organized by Faculty of Law Mulawarman University in collaboration with Law Laboratory Association of Indonesia deserve high appreciation as an effort to contribute to the development of legal science, and through the papers presented later, it is expected to be applied in solving various legal problems, especially legal problems that arise in the development process of the capital Nusantara. In the end, thank you to all parties who have contributed to the success of this event, and hopefully this event can bring benefit to all of us. Enjoy Mulawarman University, enjoy Samarinda, and enjoy East Kalimantan. Rektor, Profesor Dr. Insinyur Haji Abdul Nur, MSI, IPU. And thanks. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you for the amazing speech. I would ask Dr. Mahendra Putra Kurnia to please be staying on the stage, because next up we will be seeing the welcoming gift giving as a symbol of the opening ceremony for this international conference and national law meeting. Also, we would like to invite the leader of the Law Laboratory Association of Indonesia, Mr. Professor Dr. Juajir Sumardi, Bachelor of Law, Master of Laws, as the one who received the opening gift. For Professor, may please join us on the stage. Give a round of applause for the opening gift. Thank you for staying with us. I hope you two can stay on the stage again, because next up we will invite the chairman from the Faculty of Law, Mulawarman University, other representative, and all the speakers that are here with us to join us on the stage for the photo session. We would like to invite everyone in the front here to join us to the front for an opening picture. We would like again to invite other representative in here for joining us for a picture session. And we might want to invite a representative from the Law Laboratory Association of Indonesia, ALHI, may join us on this. Again, we would like to invite the chairman of Faculty of Law, Mulawarman University, and other representatives from ALHI, or Law Laboratory Association of Indonesia to join us for the documentation session. Thank you for all the representative. The documentation session, not just only for the representative, for the rector, or for the dean, but also for all the participants and the panelists behind. So I would like everyone to get your best shot because right now we will be taking pictures from all of you from here. I would like everyone to prepare their best shot because right now we will be taking each of everyone in here for the second documentation session. May you all please stand up so you all might be seen. On the count of 3, 1, 2, 3. Please move a step aside so all can be in one. Okay, on the count of 3. 1, 2, 3. Okay. One more. 1, 2, 3. Okay, next we will say ALHI. Ready? 1, 2, 3. ALHI! Okay, may you all please remain to be seated back. After opening our international conference and national meeting, Law Laboratory Association of Indonesia, with the theme Strengthening the Role of Legal Laboratories in Development of Nation Economic Law based on independent learning on independent chemists, we will be guided by the moderator for the rest of the speaking. Please welcome Mrs. Wiwi Harjanti, Bachelor of Laws, Master of Laws. May I present Mrs. Wiwi Harjanti, Bachelor of Laws, Master of Laws. May we give a round of applause for Mrs. Wiwi Harjanti. While we are waiting for the stage to be set up, I would like to give you a little facts about Mrs. Wiwi Harjanti. Mrs. Wiwi is a lecturer from Faculty of Law, Mulawarman University, with an area expertise in law. Mrs. Wiwi Harjanti also have several publications, including the Justification Critic for the Grand Design about the development of Ibu Kota Nusantara, or IKN to be short. Mrs. Wiwi Harjanti also have another publication with the title Seeing Indonesia from East Kalimantan, an invitation to decolonize environmental justice. This publication was fully published in. And the next up, Mrs. Wiwi Harjanti also have another publication about legal framework for climate change action for mangrove care village that is also published in 2022. Seeing Mrs. Wiwi Harjanti already joined us on the stage, may we give a round of applause for our today's moderator.
Assalamualaikum. Assalamualaikum warahmatullahi wabarakatuh. Thank you for such beautiful and flattering introduction. Pleased to meet you all. Today I will be your moderator for this conference, and I would like to give you a little background of our speakers today. Our first speakers will be Mr. Fokke Johannes Fernhout. He's been former judge and vice president of the District Court of Maastricht at Ministry of Justice, The Hague, the Netherlands. And in 2006 to 2023, associate professor of law at Faculty of Law, Maastricht University, Maastricht, the Netherlands. And then right now, he is active attorney at law at the Supreme Court, Wegmans and Fernhout Advocate in Maastricht, the Netherlands civil cases. So the civil cases is the area of expertise of Mr. Fokke Johannes Fernhout. The second speaker will be Professor Dr. Tata Prasad Sapkota, LL.M. Ph.D. From the various positions he held, allow me to mention a few. He is a professor of environmental law, human rights, humanitarian law, climate change policy, and law and legal research methodology. And he is a former dean of the Faculty of Law, Tribhuvan University, Kathmandu, Nepal, chairman of the Center for Environmental Law and Center for Human Rights, Tribhuvan University, chairman of the integrated law firm and consultancy PVT Ltd, Kathmandu, senior advocate of the Supreme Court Bar Association of Nepal, regional consultant of Nepal for regional project on climate change, Center for Environmental Law and Policy, University of Colombo, Sri Lanka, and he has been delivered guest lectures on role of law, religion, cultures for protection of environment, human rights, and the environmental justice in 6 famous universities in India from 2015 to 2023. And now he belongs to Global University Network, is known as Northeast West South or NEWS, and Global Association of Justice Education, or GAJE. The third speaker is Professor Dr. I Gusti Ayu Ketut Rahmi Handayani, SH LL.M. Her expertise area in economic law. She is currently the Dean of Faculty of Law, Sebelas Maret University, Chief Editor of Bestur Law Journal on Faculty of Law at Sebelas Maret University and active speaker at national and international seminars. And she also active speakers and author in reputable international journals H Index Scopus 10. The fourth speaker is Dr. Rohana binti Abdul Rahman, that already in the Zoom right now. Associate Professor, accredited mediator at School of Law, Universiti Utara, Malaysia. Currently, she is a Senior Associate Fellow at the Law and Justice Research Center, School of Law, UUM. Dr. Rohana teaches company law and professional practice courses at the undergraduate level and has supervised postgraduate masters and Ph.D. students at the university. Her area of supervisions includes government procurement law, anti-corruption law, insolvency law, alternative dispute resolution, and commercial law. Area of expertise of her is government procurement. Last publications that I can mention today is rehabilitation of abandoned housing project in peninsular Malaysia, reaching out to rescue mechanism in the Companies Act 2016 in 2022. And the legal aspect of illicit enrichment in Malaysia, as is it a crime to be rich? It is also published in 2022. The fifth speaker is Professor Dr. Juajir Sumardi. He is a professor of economic and business law at Faculty of Law, University of Hasanuddin, Makassar, director of Indonesian Institute of Business Law, founder and director of the law firm Juajir and Partners, general chairperson of the Law Laboratory Association of Indonesia today, and last publication that I can mention are transnational corporations and franchise law, and it is published by East Flow Publisher Makassar in 2012, and Academic Movement of Oil and Gas Sovereignty of Indonesia, published by East Flow Publisher Makassar in 2017. And the last speaker is Dr. Mahendra Putra Kurnia, SHMH, expertise area on international law, currently holds the position of Dean of Faculty of Law, Mulawarman University. His latest publications are The Impact of COVID-19 Pandemic on Effective Electronic Criminal Trials, a comparative study, and implication of relocation of Indonesia's new capital from an international law perspective. And also the other is one, mastering comparative law as a specialized skill in the legal area in Indonesia. Welcome to our speakers that already in the Zoom and in the room. For Prof. Juajir and Bapak Mahendra, silahkan untuk mengambil tempat di depan. Please join us on the stage. Throughout the conference held online and offline, I would like to welcome all the speakers here. Selamat datang Bapak Ibu yang ada di Zoom juga. And for the virtually, right now we have Professor Dr. Gusti Ayu Ketut Rahmi Handayani, Mr. Fokke J. Fernhout, Professor Dr. Tara Prasad Sapkota, LL.M. Ph.D, and Dr. Rohana binti Abdul Rahman in the Zoom. And in the room we have Bapak Mahendra Putra Kurnia and Professor Dr. Juajir Sumardi. For the first presentation will be delivered by Mr. Fokke. Mr. Fokke, are you ready?
Yes, I'm ready. But I sent you some slides. How are the slides being used?
Excuse me, could you repeat that again?
Oh, I sent you a PowerPoint presentation, and I wondered in what way the slides are shown to the people attending.
Yeah.
Or do
Okay.
you make me co-host so I can share my screen, or I don't know what's the best way to do it? Oh,
Yes, it's
it's
been.
there. Wonderful.
Yeah,
Thank you.
you're
Can I
welcome,
operate
Mr.
it
Fokke.
myself? Can you hear me clearly?
Yes, you are audible. You want to start right now?
Yeah, I'm audible. That's nice. And I just say next slide, and then somebody is showing the next slide. Is that the way it will be?
I'm sorry, I couldn't. Yes, Mr. Fokke. Yeah.
Buwiwi?
Yes. This is the
Oh,
next
okay,
slide.
there's the first slide.
Yes, please, Mr. Fokke.
Shall I just start? Is that okay? I cannot hear you anymore. That's the problem.
Oh.
Okay,
Yeah, you
I
may
just
start.
start.
Mr. Fokke, you might start.
Sorry? Saya boleh memulai, ya?
Yes. Yeah, please.
Boleh? Thank you. Thank you for the invitation to share some information with you. Also, thank you, Buwiwik, for the introduction. But you left out the reason why I was being asked to share information, because for more than 10 years, I was the coordinator of our legal aid clinic. I'm from Maastricht University in the Netherlands, and we had a very special, unique legal aid clinic for almost 30 years. And I had the honor of being the coordinator of it. And I was asked to tell you about the way we organize that can maybe inspiring for what you call laboratories. Because at the time when we started 1988, the word legal aid clinic was the word that we used for this kind of experiments. The first slide is just about the terminology. I will speak about advocates. Because the word lawyer can be translated in 11 ways in Dutch. So when I use the word lawyer, it is ambiguous. When I use the word advocate, I mean a person who studied law, who finished his master, his S2, and who has been admitted to the bar. The National Bar Association of the Netherlands in The Hague. If you're admitted to the bar, you have the right to represent your clients. That right can be exclusive in the Netherlands. So these advocates, they sometimes have the exclusive right to represent clients, and nobody else can do that. But there are many cases where that right is not exclusive. These are the smaller civil cases and the smaller criminal cases, all administrative cases. So in all those procedures, you don't really need an advocate. And that was the basis of the philosophy of our legal aid clinic. Because, can I have the next slide? Because what we wanted to do is have students experience what it is to represent a client. In that way, they will learn about all aspects of being a lawyer. Not only the legal theoretical aspects, but also all the skills aspects, including managing a lawyer's office, including managing your client, including empathy towards your client, thinking out strategies, helping your clients, but also drafting pleadings, drafting letters, and everything you can think of. That was possible because in many cases, you don't need an advocate in the Netherlands. And in those cases, it was the student himself who represented the client. Of course, in the background, there was also always an advocate. We had an abbreviation for this lawyer's office, which was APM, and I will talk about the APM. We founded it in 1988 until 2017. It was closed for financial reasons. You will see that there is a lot of money involved to have a law firm like this, and there were not that many students that could be integrated into this law firm. The faculty then said, after the crisis of 2008, you have to pay for yourself. That was the idea. You have to pay for yourself because it was a real lawyer's office with real advocates who made money. and then the balance should be equal. And we didn't manage to reach that. In 2017, we still missed 20,000 euros, and that was the reason that it was closed. But you have to realize how special it was. It was a real law firm with 4 part-time advocates. They were also PNS, they were also civil servants, they were paid by the faculty, and that is possible in the Netherlands. You can be an advocate, and at the same time, you are working for your boss. In this case, the boss was the University of Maastricht. We had 2 secretaries and a complete office. So every lawyer had a room. We had work areas for the students. We had a work area for the secretaries with a reception desk for the clients coming. We had a tutorial room because it was still legal education. We had a library, and we had a consultation room in case a client came to the office. It was inside the faculty. It was part of the faculty building, but we separated it from the faculty building with a separate entrance in another street. That was important, of course, because we had to preserve the privacy of the clients. We didn't want other students not involved in the APM to see the clients or other people who were in the faculty building. So it was inside, but still separate. Can I have the next slide, please? Is it? Thank you. Our philosophy was that this only really works when students are involved full-time for a certain period. They don't do anything else. If you just walk in and out of an office, a lawyer's office, depending also on your own availability, you will not learn that much. So we made this from the beginning an elective course. At the time, we had a period system. So we had 6 periods in a year. So no semesters, periods of 8 weeks, 4 of 8 weeks. So the APM was integrated in a period of 8 weeks as an elective course in the 3rd year of the bachelor. And it was the only thing the students did in that period. They did not have other courses. They also had to be at the office during office hours from 9 o'clock in the morning until 5 p.m. But quite often they stayed after 5 p.m. because in a lawyer's office, mostly you have to work more than during the normal office hours. There were no exceptions allowed. Students didn't like that because they always have things that are more important for them. No exceptions allowed. They had to be there all the time. At the end, they were assessed with a grade, pass or fail. So in this setting, you cannot have too many students. So it was 8 to 12 students for every period. It depended on the availability of the advocate, because sometimes they went on holiday or they had other obligations elsewhere. So in that way, we planned the number of students, 8 to 12. Can I have the next slide, please? So how did we organize those 8 weeks? Week 1 and 2, it was training, only training, 10 full days of training. We trained interviewing skills, very important, because our students were in fact the advocate. They were working under supervision of a real advocate, but they did all the work. So they also had to interview the clients. You cannot do that with just some bachelor courses that you followed. You have to be trained with simulations, videos, theory. That took 3 days. We also trained them for 2 days in negotiation skills. We gave them an introduction to mediation, approximately 1 day. Legal writing, approximately 1 day too. Procedural law, very important. If you want to be a lawyer, an advocate, you have to know about procedural law. And we taught them for 1 day about the ethics of being an advocate, according to the code of conduct of the Dutch Bar Association. Very important because we don't want them to make stupid mistakes. After those 2 weeks, they were ready to start. They were ready to start, and we did that by dividing the cases that were being dealt with by the advocate among the students. So every student got, say, 4 to 5 cases, because it's not always that in that period of 2 months, something happened in a case. Sometimes cases were waiting for a judgment or waiting for an expert report. Other cases required immediate action. That's the way we divided it. Every student was very busy from 9 to 5 every day. Can I have the next slide, please? So every morning at 9 a.m., we had a meeting. All the advocates were there, all the secretaries were there because they knew about the telephone calls, etc., and the students. And they discussed the incoming mail, outgoing mail that had to be sent, and they also discussed what to do in every case. So every student had to give a short report of his case. What happened yesterday? What are you going to do today? It's very intensive, but very good because all students heard about all the cases and they discussed it among themselves at that meeting. And the rest of the day, they were advocates. They answered mail, they answered the telephone, they were drafting briefs, they were drafting letters. But of course, nothing went out without the permission of an advocate. So sometimes a letter, well, sometimes, that happened quite a lot, had to be rewritten 5 or 6 times until the advocate said, well, this is a letter that we can send to the client or to the other party or to the court. If a student would have an interview with a client, it was always prepared together with the advocate. Okay, how are you going to do this interview? It's a new client. How are you going to start? What is the structure you're going to use in that interview? Very intensive, but very rewarding as an educational experience. A court hearing, of course, we wanted to send the student to the court hearing. So in the smaller cases or in the administrative cases, there the student himself went to the court hearing, and of course he was very well, or she was very well prepared by the lawyer. Can I have the next slide, please? If a student went to a court hearing, all the others would join. Sometimes the court hearings were for the advocate only because representation by anyone else than an advocate was not possible. But then, of course, the students who were working on that case, sometimes a case was for more than one student, they joined the advocate to see what happened in court, and others were welcome to do that as well. So that was their daily work. Intensive training, doing everything an advocate is doing in reality, but then everything, including interviewing, negotiating, court hearings. And then in the end, week 8, that was the last week, they had to write a brief for the next students, because the cases, of course, were not finished after 8 weeks. So there would be another group of students 2 weeks later, and they needed to know what happened in that case. So they got a brief from the previous students in the previous period. Can I have the next slide, please? Now, do you think a lawyer's office like that, will you have clients? Oh yeah, we had clients. First of all, the clients knew what was going to happen. Of course, they had to agree, and we made them sign a contract that they knew that students would be handling their case. Did they like that? They loved it. They loved it. Many clients came to our office because they had the idea, and that was with right, it was indeed like that. They had the idea, wow, there are 1, 2, 3, 4 students maybe working on my case, so it will be thoroughly done, but also I can always call. I can always call. There's always someone who can listen to me. And that was true, because that was the job of the students. And I don't have to pay for it. That's true too, because only the advocate's time, the normal advocate's time, not the supervision time, was charged, unless there was legal aid available and they didn't have to pay anything. Does it mean that it was a lawyer office that was not serious? No, it was a very serious lawyer's office. We had many big cases. The biggest case was about a real Rubens. Maybe you know Rubens, painter, 17th century. One Rubens is at least 20 million euros, $20 million. So we had very important cases, but we also took cases to the European Court of Human Rights with the students. There we won several cases. So we had real cases for real clients, and students were very motivated by that because they knew that it really mattered what they did, especially when they had to go to a court hearing themselves. Some didn't dare to do it, by the way, but most wanted to do that. Can I have the next and last slide, please? So this way of legal education, this elective course, was a big success, really a big success. The students, there were more students who wanted to follow the course than we had places, so they had to draw lots. In the evaluation, in the assessment at the end, the students always said, this is the greatest experience I ever had. And they still said that after 10 or 20 or 30 years, because we still know them, we follow them, we are in contact with them. And they said that was a great period. In 8 weeks, we learned so much. It was really a basis for the rest of our career, a very good basis. Some of them were, of course, a little bit disappointed at the end, because the advocates were very demanding. It should be good. And students sometimes think of themselves that they are good at everything. They're good at client interviewing, good at mediation, good at negotiation, but they are not. And they have to learn that. Sometimes there was some friction between them, but in the end, they all agreed this was the best thing I ever had at the faculty. There also was, and that's very important, a constant input from lecturers, from the faculty. They knew that we had this APM, this lawyer's office, which was part of the faculty, and they could use it as a testing ground. So they came with cases. They say, wow, this is an important case because we want to go to the European Court of Justice of the European Community to get a ruling on this. Could you start that case? So we had several cases that started like that, that ended as important landmark decisions of an important court in Europe. Sometimes it didn't work at all, but mostly it worked. So it had two sides. It was educationally seen a perfect way of teaching law in a very broad sense, because we didn't specialize in a specific field of law. And on the other hand, it was, from a more academic point of view, a good testing ground to see how certain theories would work out in the practice before the courts. So it was wonderful, but the 2008 crisis, which came with a lot of budget cuts, meant that we had to make enough money to pay for all the salaries. We didn't have to pay for the office, but for the salaries. And that was too much, because the lawyers had to spend a lot of time working with the students as well. So they couldn't be a normal lawyer and just make enough money to get the salaries back. That was very sad, but I think it was unique in Europe. In the United States, there are clinics like this, but in Europe, it was absolutely unique. We had many people coming to our legal aid clinic to see how it worked. And unfortunately, it doesn't exist anymore. And there is nothing like that in any other faculty anymore in Europe. That is sad. Well, I hope this gave you some ideas. Of course, the situation in Indonesia is completely different. There are many things that you can do that we could not do in the Netherlands, but there are also many things we could do in the Netherlands that will not be possible in Indonesia. But still, maybe you can do some cherry picking and find some nice ideas I just told you about that you could use. By the way, all the courses are still there. The interview training, the mediation training, the negotiation training. We still have everything. I still have everything in my personal archives, but it's all in Dutch. So I don't think that is very useful for you. I thank you very much for your attention. And I hope you enjoyed a little bit it's Chiquita Dongeng. It's a fairy tale because it is not reality anymore, but it has been reality for 30 years. Thank you for your attention. I'm done. Bu Vivi.
Thank you for amazing insight from Mr. Fokke. So basically, Mr. Fokke explained us about a POM is a big success to let students experience and handle cases, real cases, and then real clients, and do as much as they possible as a part of legal aid clinic in Maastricht University. I think we more or less already apply this in Mulawarman University as well. The second speaker, Bu Rohana. Hello? Dr. Rohana binti Abdul Rahman, are you there?
Yes, I'm here. Can you hear me? Can you hear me?
I can hear you very well.
I can hear
you very well.
Yes, Ibu Rohana, you are welcome to make your presentation in 15 minutes. Is that enough?
Yeah, sure. Sure.
Thank you. Please, Ibu Dr. Rohana binti Abdul Rahman.
One moment. So I'm going to share my slides. Yeah. Right. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Very good morning. The Honorable Dean of the Law Faculty, Mulawarman, Professor Juajir, the Chairman of ALHI of Indonesia, and all the participants in the audience for today's international conference. First and foremost, I would like to thank Universitas Mulawarman for having me here, for inviting me at the conference, and also Universitas Hasanuddin for recruiting me to be on the speaking panel. We have had an MOU, Memorandum of Understanding with UNHAS, and we hope to be able to have more engagement with a lot more universities from Indonesia. And I see Professor Fernhout from Maastricht. I don't know whether you still remember me. We met back in 2011 during the first Marston international counseling competition. We were University Utara Malaysia was representing Malaysia then. So it's good to be able to see you again. Okay. I think this is a very important meeting where, as far as I'm concerned, I'm from Malaysia. So we are very much into what you have law laboratory, like what we have in Malaysia for our professional year course for our LL.B program. It's about the same thing, and today I would like to share a little focus on mediation, which I think from what Professor Fernhout was talking just now, this is just part of his legal clinic as a whole. Mediation, the title of my talk today is mediation, is it an appropriate or an alternative mechanism for dispute resolution? So as you can see, I'm also a mediator, and we have been doing a few mediation courses for the students. We have, introducing mediation skills, basic mediation skills to the students in our university. as part of our professional year program. So if you can see from, sorry, slide here. So if you can see from this slide, these are the initiatives that we have at the University Utara Malaysia School of Law, where we have a course in our professional year, which is the final year. It is called the Alternative Dispute Resolution course, ADR. As my title is now, I put there, is it an appropriate dispute mechanism for dispute resolution, or it is an alternative? Generally, people take mediation as part of the ADR, or alternative dispute resolution. So from our experience, based on looking into how we address issues and how we try to solve problem, I feel that mediation should be the appropriate mechanism to resolve disputes first. We as law student or law lecturers, we have been, we have been engaging with litigation for most of our program. Yeah, we teach the student how they can actually use litigation in order to attain justice. And if we talk about access to justice, I think Law Lab is one of the initiatives where we want to make sure that more people can get access to justice. So instead of accessing justice through litigation, we can also explore the non-litigation mechanism. Yeah, and mediation is one of them. So in our ADR course at the professional year, we also have a mediation unit where we introduce mediation skills to the students. And other than that, at the national level, we also have a project called Service Learning, Malaysia University for Society, short form as SULAM, where this is a project where all the students from all universities are allowed to compete and to be engaged, to engage themselves in a community-based project, where the method that we use is community-based problem solving. And this is where we impart negotiation skill, mediation skill with the students so that they can use whatever substantive law that they have learned throughout their varsity year into the community. Meaning to say they go into the community and try to find issues or try to help solve problems within the communities. So, so this year, we have the final year student. We have about, I think, 20 groups of about 5 to 6 students per group doing or coming up with these projects in order for them to go into the community and share their knowledge and skills. And this year, it is probate administration. This is where they will be sharing their knowledge on probate, on wills, yeah, on the law of succession with the community. All right. And then the next one there, we also at the School of Law provide mediation skills and process training course. And we do this with we joint venture with external provider where we open up to the final year students for them to join this particular group, this particular course. And some part of the fundings is coming from the Ministry of Higher Education. So they also allow for some funding in order for us to, to roll out this kind of training. And last but not least, at our UUM School of Law, we also have our Legal Aid Center, an internal Legal Aid Center, where the lecturers are the consultants. We have this, we provide oral advice pertaining to legal issues for the surrounding community to the university. And we used to also to have students coming in, to learn how to go or to use the skills and go into the communities via Legal Aid Center programs. And these are part of the initiatives that we are doing at the UUM School of Law. But and I believe all the law faculties in Malaysia, they are individually, they have their own legal aid center. They also undertake this ADR course at the final year level, and the students are also involving in Sulam projects. But I think what Indonesia is having is to have, this association is a very good one where we can learn and share whatever experience that we have in our respective universities. So, okay, for today, I just want to go very quickly on, on mediation. And I believe this is just something which I think already in the know, yeah, if you're doing this ADR course, if you have this mediation or arbitration course in your own university. So really, mediation is a cooperative decision-making process, which is confidential and voluntary. And this is very different from what you have in litigation in the courts, yeah, whereby you have the mediator who will assist you, who will assist the parties to communicate with each other, to understand the parties' point of view, and try to explore ideas and options. And of course, at the end of the day, try to find solutions that can be fair and acceptable to both of the parties. It's a win-win situation rather than win-lose situation like what we have in the courts. Yeah, when you go for litigation, there will be one person winning and the other one is very unhappy because he may lose the case. Yeah, and go up the appeal ladder and stuff like that. But in mediation, we try to find solution that can be fair and acceptable, and the focus may not be your rights or whatever that you should have. It's rather your needs, whatever that you need, and try to come up with the solutions that is fair to both parties. Yeah. And basically, in a mediation, definitely mediators do not take sides. There should not be any bias. If you know any one of the parties beforehand, then you need to inform. And whether if the other party is okay with it, then you can proceed with the mediation. If not, then they may have to find another mediator who will be unbiased, yeah, who will be independent. And basically, mediation is not a counseling or therapy or where you expect to be given legal advice. And of course, we are saying that, and as I was mentioning about our mediation skill course just now, we do not only provide to the law students, we also allow non-law students to come in and join the course. So meaning to say, to become a mediator, you do not really have to be a law student, but really the legal knowledge would really be helpful, yeah, in such situation. And mediation provides a fair process, and you will also be able to share relevant information, which does not necessarily be legal in nature. Yeah, it can be your feelings, it can be whatever that you think might be the good solution for the problem and things like that. Yeah, and also in a mediation process, you are able to listen to each other's point of view. If you go to court, none of the parties can actually speak unless you are asked to speak. So your lawyers will be speaking on your behalf. And some of the time, or most of the time, whatever that you mean may lose along the way because of this legal jargon and stuff. Yeah. So in a mediation process, you'll be able to actually allow whatever that you think, whatever that you feel to be brought up and so that the other party can understand. So the focus of mediation is to find solution for the future relationship. Yeah. So you want to lift the mediation table with open heart and happy, rather than sad or dissatisfied with the whole thing. Yeah. So it's future focus. It's looking at what you're gonna have or you're gonna get out of that mediation process, rather than feeling that you're going to lose or you're going to win it all. Yeah. And of course, the mediator will not be the one who's deciding the matter for you, for the parties. It should be a mutual decision by both parties. And most important of all, the whole process of mediation should be confidential, should not be leaked out of the mediation process or mediation room. So these are part of the parties in the mediation. You have a neutral third party who becomes the mediator, and you have the parties, the disputing parties. Sometimes you can also have more than one mediator, and you can also have parties coming in with the whole troop of them. And this is where, as mediator, you need to have the experience to actually decide who is actually has the say in negotiating or coming up or making decision for the whole team. So we have to be able to see this. And sometimes we also allow for commercial issues. Mediation can also allow lawyers to come in to advise the parties. But as we know, in a mediation session, a mediator will be the center, the focus, where he will help to start off the ball rolling, and the parties then come in and share and explore the options to solve their problem. And at the end of the day, the lawyers can also draft their settlement agreement for them. Right. So that is somehow a very simplistic way of explaining mediation, in just 4 or 5 minutes. So as far as law and practice of mediation in Malaysia is concerned, we currently have a law called Mediation Act, which was passed in 2012 and forced also in 2012, where this particular law allows or promote for mediation to be explored by parties in order to solve their problem. And in that law, it is put that mediation is a voluntary process. There is no compulsory or you must do or stuff like that. It is voluntary for the parties, where mediator will facilitate and negotiate for the parties or between the parties and assist them to reach agreement. So far in Malaysia, there is no specific body that rolls out accreditation for mediators. So we have a few bodies that runs program in order to establish or in order to accredit mediators or registered mediators in Malaysia, right? So in the middle there, we have the ingredient or rather the items in mediation where the law also recognizes that a mediator should be a neutral person. So it is not really to find rights, who are at wrong, who are rights, who have their duties and responsibilities. It's rather to find, to try to find a solution or options in order to mend the relationship. Maybe consider alternative, may not be legal alternative in order to solve the problem. And at the end of the day, it should be a consensual agreement between the parties. And as we can see to the right box there, the benefits of mediation. The process is flexible, it's confidential, and it should be inexpensive because you don't really have to file any papers or you don't really have to appoint any lawyers in order to help you with the mediation process. And in most cases, you get to maintain a good relationship between the parties. Because if you go to court, you're going to expose all the dirty linen in court. Whatever that you want people to know, then you have to explain in court as a witness, when you go to the witness stand. But in mediation, you will be able to maintain the relationship because whatever you say will not go out from the room. It is confidential, it will live, it will finish there and then, and nothing will be recorded. And it is a quick process. If we look at the statistics from literature, most of these simple cases can be resolved within one sitting. Some will go to 2 to 3 sittings, but that may not be go on and on like cases in court that has so many backlogs. In all courts, around the world, if you can see. Right. So basically, this is the main principle, confidentiality and privilege. So I don't have to go into that. Having said that, I'm not, even though I say that mediation is the appropriate method to resolve dispute, but I I'm also recognizing that there are exceptions where there are cases that we cannot simply get our solution by way of mediation. So if it's involved criminal conduct, if there is a public interest, outweigh the personal interest, or that there are things that you need to discover or you need to get to investigate first. So all these issues may not be suitable in order for in a mediation process to be settled. Yeah. So there are things that still we need to use the litigation method to resolve disputes. Okay. So in Malaysia also I think again in Indonesia this is also recognized. We have a court annex mediation whereby in our rules of court we allow certain cases to be you can file your case in court, but the judges will ask you to consider or to recommend you to go for mediation first. Then if you cannot settle the case through mediation and record consent judgment, then you can proceed to go to the proper trial. Yeah. So there are these are the claims that have been using mediation in the courts, even though they have filed cases in court. Yeah. So these are also the area where I said mediation may not be suitable. Yeah. When it involves safety, yeah, in domestic abuse, it will not be possible to have a mediation session between an abusive partner with a victim partner. Yeah, or there is the relationship between the parties has already broken down, where the parties may be very difficult to settle the case, even though they come to the mediation table, or there could be also extreme conflict or imbalanced powers between the parties, and the mediator will not be will not be able to help them find a solution to their problem. And also if it's involved corruption, if it's involved bribery, criminal conduct, fraud, so that will also put the mediator in a very difficult position, and mediation in that sense will not be suitable. Okay, so I think that is a little sharing on my part regarding mediation. So as this slides puts it, life does not require us that we be the best, only that we try our best. So I think at the end of the day, all of us are trying our very best in our own capacity, in our own university, to help, improve the way we teach law to our students in order for them to be better leaders of tomorrow. And hopefully with this kind of activities, we can keep on sharing and learn from each other. Thank you very much.
That was amazing, wonderful insight from you. Please be still on Zoom, because after this we have a discussion session. For the next speaker will be Profesor Dr. I Gusti Ayu Ketut Rahmi Handayani, SHMH. Ibu Ayu, are you there?
Yeah, I'm here.
Yes, you are welcome to deliver your presentation in 15 minutes or 20 minutes tops. Is that okay?
Yeah, okay.
Okay, Ibu, the floor is yours.
Okay, thank you very much. For invitation. Thank you very much. Ibu Vivi as a moderator, an honorable Bapak Rektor Universitas Mulawarman, our college, Pak Dekan, Mr. Dr. Mahendra, and all of the speaker, Pak Fokke, Prof. Juajir, Dr. Tara, and Prof. Rohana, all of participants and committee, and ladies and gentlemen, Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera. Let me say, share our slides about the first philosophy, our topics and background from the university. Philosophy, the university is here not only to solve midterm examination or assessment and problems, but also university here to solve problems in people's lives from Seneca. And coherent with Ki Hajar Dewantara, you know, our what we call pahlawan in Indonesia, and also Frederick Froebels and Montessori, and then Rabindranath Tagore and Jampiji. Philosophy of university is to solve problems in peoples. And this philosophy, based on a policy of MBKM, Kemendikbud-Ristek, we know our open study program, university accreditation, and then perguruan tinggi negeri berbadan hukum, PTNBH, hak belajar 3 semester in out study program, and many choices program that based on MBKM. And all of the program, of course, based on 8 performance indicators or 8 indikator kinerja utama that coherence with indicator accreditation world-class university ranking. This is the philosophy and policy: freedom to study independent campus or Merdeka Belajar Kampus Merdeka. Many activities that can our students choose. Student activity out campus, like the first internship or magang, and then rural project or project di desa, teaching in school or mengajar di sekolah, and then student exchange or pertukaran mahasiswa. You know, we have our government, Ministry of Education, have program ISMA. And then research, student can join with a lecturer or professor in the research umbrella, the lecturer. And then entrepreneur, project of independent or project independent, include project of humanism or kemanusiaan. And you know, from MBKM, many students can internship in foreign countries by funding from ISMA or another fundings 1 semester in industry. And then international languages, 12 SKS and EI or big data, and also coding 12 SKS. And then we know about project in industry in Kabupaten or Desa 1 semester. And all of the activity student out campus must supervise by 1 lecturer or professor. And from MBKM, we can get many advantages, you know, 4.0 technology and 5.0 society here, significant with international languages, 12 SKS and AI or big data. Next, we know our performance in Indonesia based on 8 KPI or key performance indicators or 8 IQ based on Keputusan Menteri Pendidikan dan Kebudayaan number 3M 2021 about indikator kinerja utama or key performance indicators, both government university and corporate university. And you know, if we talk about indikator kinerja utama, will be based transformation transformation our university for 2023 that published 2020 for 2022 and published 2023. The IQ or KPI can add IQ 9 and IQ 10. You know, in IQ 9, this is rata-rata predikat sistem akuntabilitas instansi pemerintah or called SAKIP must minimum have remarks BB, and IQ 10 rata-rata kinerja penyerapan anggaran budget our university must minimum 80%, and all of indikator kinerja utama or key performance indicator, we can see the diagrams. The first IQ dapat pekerjaan yang layak, pekerjaan dengan upah di atas upah minimum regional, or become entrepreneur, or further academic, get a master. And the second, alumni can get experience in out campus, like internship, project with lecture, mengajar di sekolah-sekolah, research, and student exchange or entrepreneur. And the first and second IQ, this is significant with kualitas lulusan. And then the third IQ, we know our lecture can get or can have program or activity in out campus, both national or international inside. So they can get experience in industry or have activity in out campus. And the fourth is praktisi mengajar or professional give lecture or guest lecture in our campus, and we can recruit our faculty have some lecture from professional, and there have NIDK. And the third and fourth IQ significant with quality lecture. And then 3, 4, and 5 hasil kerja dosen yang digunakan oleh masyarakat and get international recognition. And then the last about kualitas curriculum based on the 6, 7, and 8 IQ. The 6 is program study collaboration with international relation or international university or corporate. And then the 7 is class that participative and collaborative. And the last study program that have international accreditation and also international reputation. Ladies and gentlemen, this is indikator kinerja utama in the first indikator kinerja utama or IQ1 in our faculty, Faculty of Law, Universitas Sebelas Maret. Alumni in category alumni get good job or further study or master. From the data, we can see from tracer study, of course, with we have one team, special team that called Career Development Center that manage and evaluate alumni to get a job and further study, and of course assist with tendik or tenaga kependidikan, have improved our target good tracer. And FH UNS, alhamdulillah, we can melampaui target that rata 70%. And then in IQ2, you know, this is the data from all of faculty. We have 13 faculty in Universitas Sebelas Maret, and based on the data in Faculty of Law or Hukum, we have 21% or 671 students to get IQ2 or second IQ. Student get experiences in out campus minimum 6 months and must get recognized as approximately 20 SKS. And about the choices from the student, choices majority of study activity is magang industry or internship, like in banking, Pertamina, and government too, like Kejaksaan Agung, Mahkamah Agung, Kejaksaan, Pengadilan, bagian hukum in local government, and also ministry, some ministry in central government, and also independent project and research with her or his lecturer or professor. And Fakultas Hukum have 20, based on the data, we have 21% per January 2023. And in IQ3, lecturer have activity in out campus or supervise the student, and we have target with become juara or can get champion. Update data in our system in UNS Simpek, and we have one system to note, to collect how many and what kind of prestasi from the student, our student, called Simkatmawa, sistem pencatatan prestasi mahasiswa, and alhamdulillah into 2023 in this year more than 30 students give award. And of course, thanks to all our lecturer who has a supervisor, our student. And IQ4, we can see professional to become lecturer in campus. We have some lecture from professional, from Pertamina we have, and then of course from notaris we have a lecture that have NIDK from UNS. And based on Keputusan Menteri Pendidikan dan Kebudayaan number 3 2023 tentang indikator kinerja utama PTN dan LL Dikti, indikator MAS harus dihitung from dosen NIDK, especially from IQ 4, from professional to be a lecturer in our faculty, and data berada pada masing-masing prodi. This is for example Bu Nur and Pak Bambang from Pertamina. And then next IQ 5 hasil kerja dosen yang digunakan oleh masyarakat. One of the indicator from international journal publication, and also textbook that write by our lecture. Alhamdulillah, we manage 13 journal in our faculties, and 2 of them, Bestur and Justisia, have Scopus ranking. And Alhamdulillah, Bestur have quartile 2. And in Faculty of Law, Alhamdulillah, we have 11 group research. Yeah, I hope oh yeah, sorry. Yeah, okay. 1 minute. 1 minute. We have some research group, 11 research group, and then IQ 7 participative and collaborative class. We review rencana pembelajaran semester to adaptation and mitigation disruption and elaboration with IQ Universitas. And then the last IQ 8 international study program. Alhamdulillah, our study program have international accreditation from FIBA Jerman. So ketercapaian Fakultas Hukum UNS is 100%. This is plan and step to 6 international students. Some collaboration with university, both national and international. We can do some program, international courses, teaching, international undergraduate program, and then manage journal Scopus and some scholarship, and also inbound, outbound student. I think that's all. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Terima kasih Ibu Wiwi, moderator.
That was great insight from Professor Dr. I Gusti Ayu Ketut Rahmi Handayani SHMH. To conclude, if I may conclude that Prof. Ayu explained that key performance indicators or IQ have major influence on activities and curricula implemented on Faculty of Law, not only in Sebelas Maret University, but I think this applies in all of university in Indonesia as well. And the challenge are the recognition and conversion, of course. I think we move to the next speaker. I'd like to welcome Professor Dr. Tara Prasad Sapkota, LL.M. Ph.D. Are you there, Mr. Professor Dr. Tara Prasad?
Good morning. Salam alaikum. Salam alaikum.
Hello, how are you?
Yeah, I am fine. Getting better.
That's great. So we are welcome you to present your presentation in 15 minutes or 20 minutes tops. I hope that's enough.
Okay, I will try. I will try presentation within given time. If not possible, I will take 3 or 4 minutes up to 25 minutes. Again, good morning to all. Let me start. Honorable Chairperson and Honorable Chief Guest of this inaugural session of International Conference. distinguished guests, speakers, Professor Juajir, Professor Mahendra, Rohana, Professor Gusti, and Professor Fokke, distinguished participants, paper presenters, presented at the conference venue and on virtual platforms, their faculty members, non-faculty members, students, and other helping hands, for engage directly or indirectly for making this conference grand success. First of all, I would like to express my sincere thanks and gratitude to the organizers, the Law Laboratory Association of Indonesia and the Mulawarman University of East Kalimantan, Indonesia, for organizing this 4 days international conference under the theme of strengthening the role of legal laboratories in the development of national economic law based on independent learning on independent campuses. The theme of this conference looks relevant and also focuses on economic independence for independent campuses. I must apologize for being unable to attend the conference venue due to my ill health. Currently, I am recovering from dengue viruses. Despite my health, I am trying to speak on methods and approaches of environmental legal studies. I would like to express my sincere thanks to the organizers for sharing my knowledge and experiences before the distinguished and learned participants. At the last but not least, I wish for grand success for this international conference. Let me allow for my PowerPoint presentation on the theme, pedagogical approaches to the methods of teaching environmental law. I have organized my presentation in 21 PowerPoint slides. Please, okay, thank you very much for uploading my PowerPoint. Please forward next slide. Yes. Let me introduction. I would like to start from introduction. Environmental studies provide basic knowledge of the environment to all individuals and help in understanding all about environmental condition of planet Earth. The term environment is formulated from the French word environner, which means surround. Therefore, everything that surrounds the Earth is called the environment. The term environment was introduced by the biologist van Urkel in ecology. Next slide. If we look at the status of environment, among other disciplines, we can find there is no self-entity or independent entity. It is spread over several cross-cutting sectors, entities, that is applied science. Under the applied science, physiology, ecology, biology, geology, chemistry, atmospheric science, space, marine, engineering, etc., etc. And next is health sciences, statistics, humanities and social science, and finally, juridical sciences. Under the juridical sciences, policies, laws, standards, strategies, action plans are included. All living creatures of the earth have been facing triple crisis: atmospheric, climate, and biodiversity crisis due to misutilization of biodiversity resources and inadequate study and research of environmental components. The crisis is known as planetary crisis or planetary emergencies. As a result, global warming has brought climate crisis. About 69% of species from the earth are already extinct, and another 1 million species are in extinct. and the atmosphere has been polluted rampantly. Next. The major environmental issues and their impacts. There are several environmental issues. Among them, I have categorized in 4. And that is, first is atmospheric pollution and climate change. Second, third is degradation of biodiversity resources. And fourth is depletion of natural and cultural heritages. If we look at atmospheric pollution, the atmospheric pollution degrades the quality of air, water, soil, and sound, and occurs different diseases on human, animals, and ecological system at large. If the climate change happens more frequent and intense drought, storms, heat waves, rising sea levels, melting glaciers, lakes, outbursts, lakes, and warming oceans, these effects can directly harm animals, destroy the places they live or habitats, and wreak havoc on people's livelihood and communities. The third one is degradation of biodiversity resources. If biodiversity resources degrades, happens disruption in food chain, habitat loss, imbalance in ecological system, food supply system, and shortage in nutrition. And the final one is depletion of natural and cultural heritages. It happens adverse impacts on natural resources, shortage of water sources, habitat loss, agriculture productivity effects, religious cultural belief, and spiritual feeling and tourism activities are being affected. Next. Yes, what is environmental study? We are very familiar about environmental studies. However, I am trying to explain from my one side. Environmental study is based upon a comprehensive view of various environmental systems. It aims to make the people's competent to do scientific work and to find out practical solutions to current environmental problems. Environmental studies are a multidisciplinary study that focuses on examining human interactions with the environment in order to address complex issues. It combines principles from the physical, biological, economic, and social sciences to tackle current environmental challenges. Next. If we look at the scope and importance of environmental study, definitely we see on the top of other disciplines. Environmental study is the overall study of environment. It includes concept, meaning, kinds, factors, causes, and consequences of the environment, that is living organism and non-living things. Environmental study describes the interrelationship among organisms, the environment, and all the factors which influence life on Earth, including atmospheric condition, food chains, the water cycle, etc., etc. It is a basic science about the Earth and its daily activities, and therefore this science is important for all. Next. Yes, one of the most important aspect of environmental studies is methods of teaching environmental studies. Several methods of environmental studies are being employed. These include, these are also major methods: lecture methods, discussion methods, storytelling methods, learning by doing methods, activities, or it is also known as activity-based methods. The National Curriculum Framework 2005 of India has emphasized learning by doing or activity-based methods for environmental studies. It encourages the students to actively participate in the learning process through hands-on activities. Next. Okay, this is my concern of my presentation. That's why environmental studies from legal perspective. As we already explained about environmental science is applied science, but we have also considered under the social science as well as juridical science. Now I am focusing on why environmental studies from legal perspectives. As mentioned earlier, that environmental studies are multi-sectoral, multidisciplinary, and interdisciplinary sciences. According to Salmon, however, there are so many definition of environment, definition of law, but among them, Salmon's definition is very closer to understand what law is. According to Salmon, law is the body of principles recognized and applied by the state in the administration of justice. Law is one of the significant instruments for the protection of environment. The role of law and policy is paramount for the protection, conservation, and preservation of environment. Altogether, we can say management of environment if we include all these three connotations. However, law is not understandable to the common peoples. There may be complexity and ambiguity in laws. Next. The law defines right and wrong, provides procedures and implementation mechanism for public law and policies. People obey law and order for their benefits as well as for fear of punishment. It prohibits such activities that are not environmental friendly, imposes penalties upon environmental criminals or wrongdoers. The term law encompasses policies, legislation, standards, and guidelines. Studies and action plans are the tools introduced for the effective implementation of policies and laws. The environmental legal studies is required to study environmental related policies and laws. It is also includes judgment of the competent courts. Next. Let's see the objectives and function of laws and policies. The main objective of law is to maintaining order, establishing standards, protecting freedoms or liberties, and resolving disputes peacefully. The main function of law is to secure social justice. Almost all theorists like Holland, Hobbes, Locke, and Salmon agree that law is an instrument of securing justice. Roscoe Pound attributed 4 major functions of law, namely maintenance of law and order in society, maintaining status quo in society, ensuring maximum freedom of individuals, and the fourth and last one, satisfying the basic needs of the people. Roscoe Pound considers law as a species of social engineering. Next. Yes, I have focuses on pedagogical approaches to teaching environmental law, teaching and learning environmental law. As I already mentioned, there are so many approaches applied for the teaching of environmental law. Some of them I have underlined here, focus here. Approach refers to come nearer to something. Heidi Gorovitch Robertson has suggested to adopt following approaches. It was published an article in Columbia Law Journal in 1998. He emphasized the traditional approach. Under this approach, indigenous ecological knowledge system should be taught. It is also essential how indigenous people have been practiced in order to protect the environment or environmental resources. Next is another is the semester-long case study approach. In this approach, he suggested that we teach environmental regulations throughout a semester, so that legal instruments should be taught in a semester, so that a student can learn a lot about environmental legislations. The third is interdisciplinary approaches. It comes from courses of administrative law, property law, public health law, and natural resources law. These other laws are very close to the environmental laws. Therefore, there should be studied these administrative law, property law, public health law, and natural resources law as well as interdisciplinary approaches. Another one is problem-oriented approaches. In this approach, Robertson suggests that we have to study the appellate cases and analysis to a problem solving. How a court, appellate court is a second court that is not a trial court, but it has evaluated the trial court's judgment and gives its verdict, and that is very useful to study to understand the legal problems problem in order to solve the problems. And another approach is simulation or mega course. Under this, we can assume or counterfeit methods. For example, mocking. What a case is processed in the course. The similar approach have been adopted in this simulation approaches, so that students can understand well about the legal proceedings of environmental legislations. Next. The another approach is in-house environmental law clinic approaches. This is, yes, we have applied widely. Law students learn under the supervision of full-time attorney. This is, however, a law clinic can be established within a campus, within a university, but we can hire the professional attorney from outside, and a student will learn from him. Another approach is internship programs approach. Under this approach, students can obtain practical experience in environmental law outside of the law schools. Yes. Under the law clinic, legal clinic approaches, they study inside campuses under the supervision of professional lawyers. But in this internship approach, they go outside to the law firms or courts or other agencies that are dealing with the legal issues or legal cases. They study there under their supervision. Environmental law moot court competition approach. This is also one of the emerging methods or approach to study law and policies. In this approach, participants in national or international environmental law moot courts competition, which provides positive learning experience for the students. And last one, yes. How many minutes? Okay, I will try my best. Okay. Problem-oriented case study approaches, seeking solution the series of case studies. Next. In addition to some of the eminent scholars of environmental law have been emphasized on the following teaching and learning methods for environmental law. The Professor B.N. Boer lecture methods, small group discussion methods, including drafting assignment, structured theme-based discussion and report back, self-directed role plays, case studies, and comparative law exercise methods. And Professor Siri Warnock and others emphasizes on a multidisciplinary approach and with deductive methods, lecture methods with a large substantive content. Professor Ivan Hammond and Professor Jill W. Heaps emphasize on the use of environmental law clinics, and Professor Karen Bobna-Littig, Professor Esther Van Wagner emphasizes field trips methods as well as reflective journal methods. Next. Let's see the initiatives for the protection of environment. The international community has developed different legal tools for the protection of global environment. These tools are divided into two groups: soft laws and hard laws. Hard laws have created certain obligation to the parties and make responsible for punishment in case of breach. The soft laws have created moral obligation to the parties. Both soft law and hard laws instruments have required the parties to the instrument to frame necessary policies, laws, strategies, guidelines, action plans, etc., and establish institutions for framing policies and implementation of these policies and laws. Next, methods to be employed for the study of environmental laws. I have already discussed 13, 14 methods earlier, and now I have added some other methods. There is no single method that can be applied for the study of environmental policies and laws. Rather, there is a need to adopt all the methods used in the study of environmental sciences, engineering, management, social science, and juridical science as well. Therefore, several methods need to be adopted for environmental legal studies. These include tutorial methods, lecture methods, discussion methods, learning by doing methods or activity-based methods, storytelling methods. Please next. Problem-oriented methods, field observation method. This is also one new one. And case study methods, moot court methods, internship, externship methods, and court observation methods, seminar and workshop methods. These are three R's I have added in the above methods. Next one, let's approaches to be employed by environmental, approaches to be employed for environmental legal studies. I have focused on, please next slide. Excuse me, yes. Approaches to be employed. In this approaches, I have emphasized on critical thinking approach and analytical approaches. Why I focus on this critical thinking and analytical approaches for the study of law or legal studies. Critical thinking involves identifying, evaluating, and constructing arguments. Critical thinking can be taught by asking questions that makes the students from their own beliefs on common topics. Promoting group discussions enables the students to listen to others and share their opinions. There are two vital elements of critical thinking approaches. One is reasoning, another is point of views. Next, please. According to Michael Scriven and Richard Paul, critical thinking is the intellectual, disciplined process of actively and skillfully conceptualizing, applying, analyzing, synthesizing, and or evaluating information gathered from or generated by or observation, experience, reflection, reasoning, or communication as a guide to belief and action. It is based on universal intellectual values that transcend subject matters divisions, clarity, accuracy, precision, consistency, relevancy, and sound evidence, good reasons, depth, breadth, and fairness. There are four approaches to critical thinking: asking questions, gathering relevant information, thinking through solution and conclusions, and last one is considering alternative system of thought. Please next slide. Next slide, please. Yeah, analytical approach. This is the second one, our last one. An analytical approach is the use of an appropriate process to break a problem down into the elements necessary to solve it. Each element becomes a smaller and easier problem to solve. Analytical means the use of analysis to solve problems. Analysis is breaking a problem down into smaller problems so they can be solved individually. Good analysis uses a process to direct the analysis. Analytics is a broad term covering four different pillars in the modern analytical models: descriptive, diagnostic, productive, and prescriptive. Next one, please. Now I'm almost in the end. Why analytical and critical thinking? I propose two analytical and critical thinking approach to study the law, and I would like to justify why analytical and critical thinking approaches in environmental legal studies. A legal expert or lawyer does not believe on the statement without observing the fact based on the cause and effects. The student of law should have an analytical and critical thinking capacity. This capacity can be developed through study and practices. The students should think from different angles or point of view. The student can develop analytical and critical thinking by using 4W1H model, such as what, why, when, where, and how. The student should try to find out the clear answer to those of these questions. In order to find out the answers of these questions, the student start thinking critically and at the same time becomes analytical. Next one, less concluding remarks. Environmental issues are complex, cross-cutting and multidisciplinary. The earth is in triple crisis: pollution, climate change, and a loss of biodiversity resources. The adverse impacts of climate change have been threatening to all living creatures on the earth. International community has become aware about it and has also been attempting to address the environmental issues by adopting a number of measures like legal instruments, techniques, institutions, technologies, methods, and approaches of teaching environmental law. Governments and regional associations are also showing commitments to adopt the recommended measures, but these are not implemented effectively, and thereby these commitments are not fulfilled yet. Next. Yes, environmental education is one of the significant means to aware the peoples of the world. This is also taking place from primary to university level, but there is no uniformity in imparting environmental education across the world. Neither there is uniform curricula nor adopting required teaching and learning methods and approaches in environmental studies. Environmental legal study requires several methods, along with critical thinking and analytical approaches. These critical thinking and analytical approaches are best suitable for environmental legal studies. It seeks reasons and point of view backed by 4W1S model. There is a need to adopt several methods of teaching and learning, along with critical thinking and analytical approaches to combat triple crisis facing by Earth and all living creatures depending on it. Thank you very much. If there are some questions, queries, or suggestions, I would like to welcome and try to respond the queries and questions. Thank you very much.
Sapkota. Please still on Zoom because after this we will move to the discussion session. Already concluded by Professor Tara Prasad Sapkota earlier, but I must say that his presentation mostly talk about environmental legal study requires several methods, and according to him, critical thinking and analytical approaches are the best suitable for environmental legal studies. The next speaker is Professor Dr. Juajir Sumardi, SHMH. Bapak, are you ready?
Ready.
Okay, you got 15 minutes for your presentation.
Okay.
The floor is yours.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everybody.
Good morning. Good morning.
Let me to present my paper, and I hope I will finish my presentation, and I want to shorten my presentation because the available of time. The title of my paper is State Sovereignty in International Contract on Oil and Gas Management, an overview of Indonesia practice. As we know that oil and gas are strategic natural resources for the survival of the nation state. Oil and gas is a non-renewable energy. We know that oil and gas produced by the energy fossil energy. So that oil and gas cannot renewable. the characteristic of the oil and gas industry are high risk, high technology, and high capital. Can you run next the slides? Yeah. Nah, to change the potential of oil and gas resources, how to change it to become a real asset, it is necessary to carry out exploration and exploitation. We must do exploration and exploitation. And all of the developing countries has not available technology and capital, because to exploit about the oil and gas need high capital and high technology. So the state built a cooperative relationship on oil and gas management through international contract with international oil company. Next. Now, in my paper, legal issue is what is the position of state sovereignty in international contract. We want to ask the position of national state in the contract. In the case is the sovereignty of state in cooperation to exploit of oil and gas. Next. And there are 3 research questions. 1, how the state control over oil and gas management cooperation. Whether in Indonesia we have control or not. No day. Is it possible if a state energy sovereignty be degraded by international contract or oil and gas management? And the third is how Indonesia should respond to energy sovereignty of oil and natural gas based on Article 33, Paragraph 2 and Paragraph 3 of the 1945 Constitution of the Republic of Indonesia. This is the problem in our state in Indonesia, especially exploitation of the oil and gas. Next. The cooperation between government of a country, in this case is host country, and foreign companies on oil and gas industry in generally determined by contract who are negotiated by the state and company. In practice, state control existence to oil and gas management will be influenced by its of chosen cooperation form. Next. In the practice, there are 4 type contract for exploration and exploitation of oil and gas. The first is concession agreement. The second is joint venture contract. The third is service contract. And the fourth is production sharing agreement. Next. We must know about the content concession agreement. In the concession agreement, the legal position of foreign oil company as the owner of the oil and natural gas they manage. So that when we choose the concession agreement, oil and gas owned by the international oil company, so that host country has an status as a owner of oil and gas. International oil company has control right over all management activities that they carry out and bearing the risk of the loss incurred. And this agreement have done from the 1940 to 1950. And the joint venture contract, we know that the existence of joint venture contract show a rational reaction and a struggle of the host country to lead more profitable in oil and gas management cooperation. So that this is the antithesis of the concession agreement, because the developing countries feel that the profit, the biggest profit, just used by the company. So that all of the developing countries want to change from the concession agreement to be joint venture contract. And the production sharing agreement next. International oil company in production sharing agreement mandate to provide technology, capital and services to carry out exploration and exploitation activities of oil and gas in the work area agreed by the host country. So that this is difference between production sharing contract and concession contract. Next. Yeah, next. Yeah. This is the comparison of ownership, control and risk on concession agreement and production sharing agreement. We can show that the ownership in international oil and company, IOC is yes, but host state no, not as a ownership. But control, this is difference between concession contract and production sharing contract. Next. This is the comparison ownership, control and risk in service contract cooperation. Next. In practice, we know there are usage of stabilization clauses in the cooperation based on the contract, international contract. We know there are clause, its name is usage of stabilization. What is the usage of stabilization clause? International oil company wish to minimize political risk, administrative risk, and legal change risk in host country. IOC intensify the imposition of the international minimum standard protection so that the international oil company want to protect their interests through the contract. And the international oil company wish to enforce of the doctrine pacta sunt servanda principle. So that they want to protect their interests from the intervention of a host country through implementing of pacta sunt servanda principle. International oil company carry out the risk minimize strategy by building a stabilization clause. We know in the contract, the IOC use the stabilization clause to protect their interests from the interference of host country, especially the policy of the host country. Next. I will shorten my presentation. Next. How Indonesia should respond to energy sovereignty of oil and gas resources. How must we respond about the condition, exploitation of oil and gas in Indonesia? Based on doctrine of permanent sovereignty over natural resources that emitted by international law, so that every state has permanent control to the exploration and exploitation activities on oil and gas carried out in its territory. so that all state has permanent sovereignty over natural resources. For Indonesia, the concept of control by the state philosophically in line with the spirit of Article 33, Paragraph 2 and Paragraph 3 of the 1945 Constitution of the Republic Indonesia. The aim of state control over its oil and gas management basically is to create national energy security for prosperity of all Indonesian people. This is important. How to create the prosperity, how to create the energy security in our country. Because almost the exploitation of the oil and gas have done by the international oil company in Indonesia. More than 40% exploited by international oil and gas company, not national oil company, for Nodai. Okay, next. This is Indonesia's legal standing on oil and gas management. Next. And this is Indonesia, the sovereignty theory adopted by Indonesia. We can show about the sovereignty theory. Next. And this is energy sovereignty stipulated to the 1945 Constitution of the Republic Indonesia. We know that we have sovereignty to exploit our natural resources. Next, this is the existing condition of oil and gas management in Indonesia. Yeah. Next, and this is the map of US and other countries' ownership of the oil and gas working area in Indonesia. More than 80% exploitation of gas and oil in Indonesia exploited by the international oil company. We can show the other flag. Next, and this is position, Pertamina, the red. Next, existing condition of oil and gas management in Indonesia, about 85% the oil and gas working area managed by foreign company. And national company only control approximately 15% of the work area. And the percentage above show a very small value when compared to Malaysia. Malaysia 30% and China 85%, controlled by the national oil company. And the conditions have changed Indonesia's status in oil production sector from net exporter to become net importer state. Not exporter again, but to become net importer of oil and gas. This is the reality for nowadays. Very danger. What should be done by Indonesia? Indonesia must enforce and implement the substance contained in Article 33, Paragraph 2 and Paragraph 3 of the 1945 Constitution of the Republic Indonesia. I think we must implementing about the regulation, especially the Constitution of the Republic Indonesia. And the government does not extend to contract on oil and gas management cooperation after its validity period ends and turn over the management of oil and gas to the state-owned company, in this case is Pertamina. And Indonesia must make amendment and update the law number 22 2001 concerning oil and gas. This is my picture when I am struggle, my fighting to stop our government to extend the contract in Blok Mahakam and Blok Rokan. Because our government will to continue to extend about the contract. This is the picture when I lead the demonstration in front the state palace in Jakarta. And this is the demonstration when I try to stop the government to extend of the contract on Blok Mahakam. And this is when I proclaim Indonesian oil and gas sovereignty in Jakarta, April 2015. And Alhamdulillah, my effort to stop of our government for extent of the contract is success, and nowadays Blok Mahakam already back to Ibu Pertiwi. Conclusion, oil and gas management has high value and contribution for the greatest prosperity of the people. Therefore, oil and gas management must be controlled by the state. International contract on oil and gas management cannot eliminate the existence of energy sovereignty owned by its state. Therefore, the position of the country's energy sovereignty of international contract is permanent. This is reinforced by the recognition of international law on the principle of permanent sovereignty of natural resources. For Indonesia, the principle of control by the state is philosophically in line with the spirit of Article 33, Paragraph 2 and Paragraph 3 of the Constitution of the Republic Indonesia. Energy sovereignty is a crystallization of the ability of state to have the power to control, regulate, and manage the energy it has. And every form of cooperation contract in oil and gas management involving international oil companies must place the state in a dominant position. And the Indonesia government must provide concession right to a state-owned company position as a special oil and gas business entity to represent the state in conducting international investment contract in the field of oil and gas management. This juridical construction building be placed the sovereignty of state and energy sovereignty of state permanent without the opportunity of face challenger from international oil and company. In other words, international cooperation in the management of oil and natural gas is built of the level of business to business, not government to business like nowadays. SKK Migas represent of the state doing contract with the company. This is danger because no liability of no limitation of liability between SKK Migas and state. I think this is my presentation. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. That was amazing presentation, Prof. Juajir. It's interesting because we already talked about the sovereignty of natural resources, not only gas and oil, but all the natural resources in Indonesia. We should move to that talk, how to make our sovereignty and pass the international pressure. Okay, thank you very much, Professor Juajir. Next, we are moving to Mr. Dr. Mahendra Putra Kurnia as the last speaker. Pak Mahendra, I have to remind you that you have only
50
minutes.
Okay.
20 tops. 20 tops. The floor is yours.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. I have a different perspective of the presentation because I will look the legal laboratory from the management situation. Because in my opinion, if we want to make a high quality research or high quality community service, especially with the theme of economic law, we must have a good standardized of legal laboratory. So I will deliver or I will present about the legal laboratory for the achievement of SKL and GPL plus MBKM. Independent learning on independent campus. Okay, for the first slide. Yeah. As we know, every study program must have, like in the presentation, like in the refer to the Peraturan Menteri, the newest Peraturan Menteri Pendidikan Kebudayaan Riset dan Teknologi number 53 2023 tentang penjaminan mutu pendidikan tinggi. Every study program must have SKL or graduate competency standard and must have CPL or learning outcomes of student of program graduates. And in this situation we have to focusing on learning outcomes of Bachelor of Law study program graduates. And refer to the Peraturan Menteri, every program study or every study program Bachelor of Law, every alumni must mastery of science and technology, specific skills, and their application for one or a certain set of scientific fields. So in the newest Peraturan Menteri, not only Bachelor of Law, not only mastery of law science, but the other science. And it's related with our topic today, that economic law. So every students in Bachelor Law must know about how the law science and how the economic science in order to make a high quality of research or community service in economic of law. And then they have to general proficiency, kecakapan umum, and knowledge and skill needed for the job market, and or continuing studies at higher level or to obtain a professional certificate. And the last, the learning outcomes of Bachelor of Law study programs must have intellectual ability to think independently and critically as a lifelong learner. So this is the basic how we start, how we arrange the Bachelor of Law and the learning outcomes. So,
Pak Mahendra, you should talk louder because Mr. Fokke said he can hear you.
Okay, maybe I have to change the microphone. Okay, it's more louder, right? Yeah, the microphone is the important things to make my voice louder. Okay. And the next slide, after every program study must have the graduate competency standard and the learning outcomes. So we derive to the key competencies. Every student in Bachelor of Law must mastering theoretical concept of certain areas of knowledge and skills in general and especially to solve problem procedurally in accordance with the scope of work and able to adapt the changes of situation faced. So every student in a Bachelor of Law, like we said in the last slide, that I said that every student in Bachelor of Law must mastering not only law science, but the other science they have to know. At least they have to learn the basic science of beside the law. And The achievement of graduate competencies is giving a final project that can be in form of thesis, prototype, project, or other similar form, or final project either individually or in groups. Or the application of project-based curriculum or other similar form of learning and assessment that can demonstrate the achievement of graduate competencies. And then in Bachelor of Law, the level of deep and breadth of the learning material is science as technology, which is scientific basis of the study program, which is law science, cutting edge science and technology relevant to the program study, new concept resulting from recent research, and the world of work that is relevant the profession of study program graduate. This is the arrangement in the newest Peraturan Menteri Pendidikan dan Kebudayaan Riset Dikti tentang penjaminan mutu pendidikan tinggi. So we have to make these rules as a basic to arrange the learning in a Bachelor of Law program study. And then this is the point is, and next slide. Every students in Bachelor of Law must, the point is knowledge, skills, and job market. So in the Bachelor of Law, every student must knowledge and skill needed for the job market or continuing studies at a higher level or to obtain a professional certificate, such as every students in Bachelor Law must able to draft laws, peraturan perundang-undangan, must able to draft contracts, must mastering judicial procedural law, hukum acara, and able to contribute to solving the problems. That's the minimal competence that every bachelor student must have. And then beside the science, beside the theories, every students can apply the theory on procedural skills course and work skill course, or in procedural law and judicial practice. Every students in Bachelor Law can do the legal audit and legal drafting, contract drafting, and alternative dispute resolution. So based on the theory, in the middle of their study in the third or in the fourth year, they have to apply the theory that they had in the semester 1 until semester 4. And this is the role of the lab, legal lab. So in order to make supporting Tridharma perguruan tinggi and the implementation of GPL and SKL achievement, legal lab have their function to increase the legal ability students and lecturers. So I mean is we can learn the theory in the class, but we can practice the theory in the lab. Just like in the exact or in the exact science that they learn the theory in the class and they bring the theory in the laboratorium. It's same as with us in the Bachelor of Law. So we learn the theory in the first until fourth semester, and then we bring the theory in the lab. What is the lab? Next. The legal laboratory standard. Before we have, we get a high quality of the students in order to fulfill the GPL or SKL, we must have a legal laboratory standard. This is in order to meet standardization of our legal lab. First, the facilities standard. The first standard is facilities in infrastructure. I mean is quantity and the quality of building a room and equipment. So we must provide the situation that make a student can learn in our laboratorium, in our maybe for example in contract drafting lab. So we have to give a computer as internet with a huge bandwidth. We have to give a big screen, and we have to give the room for discussion. So it makes the student can learn and can practice the theory about contract drafting. So they just not only learn from the theory, but they can apply it. And we have to provide the sarana and prasarana, facilities and infrastructure. We cannot have a good student with the good ability in drafting contract if we don't provide the infrastructure, the structure. So this is the first standard for our legal laboratory standard. And then the second standard is governance and cooperation. The quality of internal management, I think this is a normal situation in every lab. They have must have a quality of internal management, the chief of the lab, the laborant, and the other person who have responsibility to run the laboratorium. And the laboratorium must have ability to cooperate with external. Like our themes today, we want to make a development in economic of law. So our lab in contract drafting must have a cooperation with maybe a tax lab in the other faculties or in the economic faculties. So if they have cooperated like that, so we can produce the high standard of students with the high ability to make a contract. Because if we talk about contract, we always talk about tax also. So if we can, our lab of contract drafting can cooperate with the tax lab in the facultas, in economy faculty, so we can produce a good student. And three is, the third standard is human resources. The quantity and the competence of lecturer and staff. I think this is the most important situation. I think if we have not good or rare facilities and infrastructure, but we have good human resource, so we also still can produce a good outcomes. But if we don't have a good human resources or quality high resources, human resources in the lab, so if we give them the best technology, even we give them the best technology, so they can use that, they can use it for the output. So I think human resources is the most important things in this standard. And the fourth standard is services. Services is related to the operational procedures. So every lab, I think, must have a standard operational procedure. And the last standard is even though we are in the not like in the chemical laboratory or like in the technical laboratory, we must have availability of cleaning, health, and safety equipment. Even though in our lab is only have a chair, only have a computer, or only palu sidang, I think, if in the lab of procedural law, I think. So it must be still need the occupational of hygiene, health, and safety. I think keselamatan kerja, safety work is upon this laboratory. So you'll never get the excellent result if you don't set high standard for yourself. So if we want if we want a high result or excellent result, so we have to make a standard, a high standard to our legal laboratory. And then next, the last presentation. Okay, if we have standardized legal laboratory, like in the last slide, in the previous slide, we can easier to implementation of the Tridharma of higher education and MBKM that meets the national standard of higher education and has the unique characteristic of its faculty. So the MBKM programs that can support by the legal lab, such as independent study or independent project, building village, humanitarian project, and research itself. And then if we have a good legal laboratory, if we have a high standard legal laboratory, it's easier to make to fulfill the MBKM situation, and also we can fulfill, like Prof. Ayu said, indikator kinerja utama. And the key is we have standardized legal laboratory. And also I suggest if we have unique characteristic in every faculty, we can use it for our advantage. Such as in Mulawarman University, we have tropical studies as a scientific pattern. So we develop the legal laboratory with the scientific pattern legal tropical studies. And we discuss the specification of case or contracts or laws in mining, forestry, oil and gas, like Mr. Professor Juajir said in the previous presentation, and coastal and marine and climate change. So if we have unique characteristic, and I think every university in Indonesia have their own unique characteristic. So we can use the unique characteristic as the advantage. So maybe maritime characteristic in Universitas Hasanuddin. If we want to get information or research about economic law in shipping, international shipping, so we can go to Universitas Hasanuddin. If we want to get high quality of research in, for example, for us in mining law, so you can get, so you can come to us, because we have so many high quality research, and it done in our legal lab, in our legal laboratorium. So I think for the conclusion, if we want to make or if we want to produce good quality or excellent quality of the students, so we have to strengthening the lab with the standards, with the high standards. I think that's all of my presentation. Thanks for the attention.
Thank you for Mr. Mahendra for the great insight. I think that also includes all of our presentation session, and so we have heard all the insights from all the speakers, and now we move to the discussion session or question and answer. So I would like to invite you all the participants in the Zoom and in the room to raise your hand, ask question, and for the participant in the Zoom, please raise your hand first before you ask, or you can write down your question on the chat box. For the participant in the room, you can ask a question or questions maybe. You can raise your hand and state your name and to whom that question addressed to? Please. Maybe I would like to offer a question first to, because they look so sleepy. To Professor Tara. Professor Tara Prasad, are you still there? Hello?
Hello, yeah, I'm ready to answer. I'm ready to answer.
Yeah, I have one question for you.
Yeah, please.
Indonesia
Yeah,
is
please.
Indonesia is known as abundance of natural resources and exploitative policies. I don't know if you know this, but it is what it is. What do you think of the most effective way to escape the natural resources course? And how do you view this from the method and approaches you have described earlier?
Okay.
That one for Professor Tara, and to Dr. Rohana binti Abdul Rahman, I also have one question for you. Does mediation work in environmental cases? Does this work? And how effective is the mediation in those cases? Maybe you can give us an example from Malaysia experience. Okay, we have one question from Mr. Dedi. My question is to the speaker, Ibu Professor Rohana. First, in Indonesia, in civil cases, it is possible for the parties to reconcile until there is a decision from the court. Is Malaysia also like in Indonesia when the parties reconcile in the ongoing court process? The second one, is there mediation facilitated by courts in Malaysia when a case is registered with the court? That's it, Ibu Rohana. Any participant, do you want to ask something? Yes, please.
Good afternoon. My name is Teresa. I would like to ask to several speakers that have presented such an amazing insights, I think for me and for all the representatives in here. First, I would like to ask Professor Fokke and Fernhout. First, I would like to ask Professor Fokke Fernhout, as he was mentioning about how legal students can approaching in some several cases. I would like, were there any sort of exceptions, like students cannot handle this kind of cases because of this? Because I find it really interesting as a legal student myself for knowing that I can handle some several cases, but would it be another exceptions looking at the Maastricht University for legal students handling cases? Okay, that's the first one. Should I continue? Okay, the next one is for Professor Dr. Juajir. As mentioned in the presentation, we were talking about sovereignty, and it basically means the supreme power, or for short, authorities. Seeing in Indonesia about drafting contracts and several stuffs that are related to the supreme of power from other peoples or authorities. What if the authorities or people with this supreme power agreeing with the holder for such an invasive kind of mining and endangering most of lives or most of the environment? I ask for your opinions about what do you think about those holder or those people with authorities that give the holder that somehow the thing that they're doing is very invasive. And the last one is for Dr. Mahendra. As it was mentioned about the MBKM, I would like to ask, the program is implemented the standard for higher education. The program was meant for us to have more higher values in the future. Besides MBKM, what are other ideas or opinion based from you that will increase our standards or our form of education? I think that's all my question for Professor Fokke, Professor Juajir, and Dr. Mahendra. Thank you.
Okay, for the first one to answer, Mr. Professor Tara Prasad, do you want to answer first?
Okay, thank you. Okay, thank you. Thank you for asking questions. Towards my presentation, she has asked natural resources method and approaches for the conservation of natural resources. Yes, natural resources is one of the basic components of environment. Without conserving natural resources, we cannot survive. Or we cannot continue our existence on Earth. Therefore, if we find it conservation of biodiversity, almost all natural resources do not cover. If we talk about natural resources, almost all the component of biodiversity are covered up. So far as I am focusing on teaching methods and approaches to environmental legal studies. My present focus on teaching environmental law, legal studies, and approaches and methods of environmental legal study. Therefore, natural resources so far as conservation of natural resources should adopt integrated and comprehensive methods. Integrated and comprehensive method. Without integration, we cannot study the natural resources in isolation. We have to study other factors, other components as well to understand the value of natural resources. Therefore, I would like to focus on natural resources cannot be conserved without using integrated and comprehensive methods. At the same time, we have to, whereas we teach natural resources in universities or school levels, we have to focus the approaches, critical thinking, as well as analytical approaches in order to understand. As a law professor, as a law student, we have to be a critical thinking. We should not understand, we should not believe on the first saying, that we have to check and we have to verify, rectify whether the statement given by someone is correct or not. And what are the logic behind that? What are the factors to say so? These are the things we have to take into consideration while we study, we learn about natural resources. Thank you.
Yes, no problem. Thank you for the question. The question was whether there were exceptions in our legal aid clinic for the students who in dealing cases. No, there were no exceptions. All students had to sign a contract with the duty of secrecy, so they could talk with all the clients, and they were not allowed to bring out any of the information outside the lawyer's office. They would participate also in cases where only the lawyer, the advocate, could go into court. But until then, they did everything. They wrote the briefs, they wrote the pleadings, they talked with the clients, they negotiated with the other party, all under the supervision of the advocate who was in charge of the case. So they really did everything in any case. That was interesting. I think that answers the question, but I also received a question from the chat, which maybe I could answer at the same time, from Birka Latif. She asked me, is there any suggestion to link the legal aid mechanism and the legal clinic here? for your information, legal clinic is a course in Indonesia. Of course, I cannot answer that question because it's about Indonesian law. I have no idea, and every country in the world has its own system. What I know is that, for instance, in Croatia, legal clinics are funded by the government. So it's a way of giving legal aid by giving money to the law faculties. There are not that many there, but there are some, to start a legal aid clinic and even provide for transport and things like that, because they have clients high up in the mountains who never come to the city and that who still need help. So governments can give in that way a kind of legal aid. In our case, there was no problem regarding legal aid because it had, you need a lawyer, you need an advocate to get legal aid. So we had 4 advocates and they just applied for it and they got it. I hope that answers the question of Bob Bilka. Thank you for the opportunity.
Sir.
Yeah, thank you. Based on the law number 32, 2009, concerning about the protection and management of environment, governing about the responsibility of state and the society. So that when you saw about the company exploit the environment, especially maybe coal or oil and gas, create the impact to the environment, you as a people has right to sue directly in front of the court. That is the sue of class action. Class action. You can directly to propose class action in front of the court when you sue. There is the company maybe in East Kalimantan, yeah, doing the mining, create the impact of the environment. Besides that, the responsibility to protect of our environmental, not only right of the state, but right of the people. We want to increase the awareness of our people to protect and to secure our environmental and to stop the activities of the company when its activities arise the damage of the people. This is our common responsibility to protect our environment. Like in international law, when the state didn't implementing the duty governing in international law, so that the state can be sued in front of the court by the damager. Thank you.
Is that enough?
I think that is enough regarding that. When it comes to endangering the precious life, we can sue the people or the authorities that are doing the job by doing the class action kind of thing for protecting our lives. Is that so? Right?
Yes, I think in practice, like in the people at the Rio, they sue the Chevron. When the Chevron make the activities cause the damage of the environment. And now the case is still running, so that you have right and you have responsibility to protect your environment in East Kalimantan.
Yes, thank you. I've heard it very clear.
Thank you, Tere. The next one is Dr. Rohana binti Abdul Rahman. Are you ready, Bu Rohana?
Yes, I'm ready.
Yes, please. Floor is yours.
Okay. I think I have two questions in the chat box. The first one is regarding whether Malaysia, like in Indonesia, can we reconcile cases, ongoing court case, through mediation? Yes, as I was presenting just now, very briefly, I think. You can start. You can file your civil in court. And before even at the pre-trial case management, before you actually sit down for full trial, we can request for the case to go for mediation. It's either the parties request or the judge can consider and recommend to the parties to go for mediation. And also in my slide just now, I also mentioned very briefly on the court annex mediation that we have in Malaysia. So currently in Malaysia, there is a practice direction under the courts where we allow for several or a few types of civil suit to be recommended to go for mediation, in order to settle the disputes. And when they agree with the terms, they can come back to court and register or record the consent judgment or the settlement agreement. Okay, so that is the position in Malaysia currently. And I think I have also questions regarding, is there any example of mediation being used in environmental law cases in Malaysia? Basically from what I know and what I have read, the practice direction that we have for court annex mediation is actually applicable also to environmental law cases. It's just that when we looked at the cases in our environmental courts, basically our environmental court is only looking at the offences under the Environmental Quality Act, the only act that we have prescribing the offences under the environmental law. So basically these cases will go for trial in court. However, there has also been scholars in Malaysia that promotes or recommend because as I said just now, our practice direction does not restrict the cases that can go for mediation in our civil courts to actually has not been restricted to certain cases only. Therefore, it can include environmental law cases. And if we looked at the other statutes or legislations that we have in Malaysia, for example, if I can quote the Town and Planning Act 1972 that we have, there are provisions in this particular act or statute that says whenever any planning authority they want to come up with a development project or something like that, they must allow for public consultation. So public consultation can appear in several forms. And I believe this is where the appropriate mechanism to settle any queries, any disputes, any misunderstanding, any miscommunication can be done via mediation process, for instance, via negotiation process, for instance. So before the actual development project can take off, there should be the process or the people who are involved, the stakeholders, they must be prepared to allow this mechanism to be operationalized so that the whole process can actually occur in a win-win situation manner. So there have been also call by academics in Malaysia for the victims of the environmental violations, and also the perpetrators to be allowed to go for mediation, even if the case has actually gone to court. The way it has been done is that, like I said just now, the court annex mediation can be used for this purpose. So the mechanism is there. I think the will of the people and the will of the parties concerned, the knowledge, and the knowledge and the trust in the system has got to be there for them to use this appropriate mechanism to solve their disputes. So that is my response to the question. Thank you, Ms. Moderator.
Her question, she will cut off our occasion because he's the MC. Because he's the MC. He have an authority to cut off this event, okay? Okay, I think it's every faculty in Indonesia, I think now must involve in MBKM programs. So I think after 2 years we involved in this MBKM program, I think there is several positive situation that we can get from the MBKM programs. One of the positive situation or one of the advantage situation is if we can send our students go to another faculty that they have a more higher standard, like we did in last 2 years. We send our we send our student to several faculty of law in Java, that they can have opportunity to make they can have opportunity to get more high value and more high science knowledge in the more situation, in the other situation, just not like in our faculty. So I have to admit that our facilities is not too good and rare situation, and I think the MBKM program give an advantage to faculty like us in the to send our students to get more knowledge and experience in other faculty that have who have a higher standard than us. So that's the advantage of MBKM programs, I think.
Okay, thank you very much. Terry, do you want to add something? Maybe a rebuttal? Enough. Thank you, okay. Mr. Din. We have Mr. Denny Selamat Pribadi in the Zoom. Am I audible, Pak Denny? Hello?
Thank you. Hello. Thank you. Hello.
Yes, please.
Hello. Hello. Yeah, my question is for Professor Dr. Juajir and Dr. Mahendra. My question is whether it is possible for us together with several universities to conduct a contract drafting and moot court competition related to civil procedure in the coming year, maybe. Thank you. Just that.
Thank you, Mr. Denny. Is it possible?
Yes, of course. It's very, possible to make a cooperation with other faculty that who have a legal lab, and to make a cooperation, especially in contract drafting or something like that. So we will arrange with this. We will start the cooperation with this occasion, right? So tomorrow we have a sign of cooperation between ALHI and several dean in law faculty. One of the implementation of that cooperation is we must have some event to promote or to discuss about what we will do after the signing of MOU. And I think the first idea is how to make a cooperation in order to develop our contract drafting laboratory. I think it's very possible.
Yeah. Me. In Indonesian Law Laboratory Association, I think we offer to all Faculty of Law to make cooperation with ALHI, especially to create the joint operation for short course maybe, especially to give ability of our student, especially to know about the legal practices in the fact, because before our student pass in the formal education, they need to know about the existing condition of the legal practices in our situation in Indonesia maybe, and before they submit the job, they know about the ability of practice in legal cases. And ALHI want to create the system, especially about the standardization, to increase and to enhance our student in faculty to have ability, especially the legal practices. I think that is very important to cooperate between ALHI and the faculty management. That is my opinion.
Thank you for Mr. Mahendra and Prof. Juajir. Is it enough? Tere is gone. Tere is gone. So I think this is conclude all of the event we are today. What an amazing and interesting topic we got from presentations and then discussion. I would like to send my gratitude to all of the speakers, panelists, and everyone who eagerly joined this conference. Thank you very much. Harjanti will give back the rest of the event to the Master of Ceremony. Tere, silakan. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
After hearing such an amazing insights from all of our speakers, online or offline in the room with us, thus is an end of the International Conference and National Meeting, Law Laboratory Association of Indonesia, with the subject, Strengthening the Role of Legal Laboratories in Development of Nation Economic Law based on independent learning on independent CAMASOS. Thank you for all the speakers, moderators, and all participants that join us here or virtually in our Zoom or YouTube. May all the insights on today's conference will be useful for us in the future. Good afternoon, and wassalamualaikum warahmatullahi wabarakatuh. All the invited guests, besides the students from Faculty of Law Mulawarman University, please stay in the seat because there will be another announcement for the movement to the Faculty of Law.